Well, thanks everyone. I'm going to talk about what you can see on the screen there, particularly about the thinking about the canon, if you like, of cases that we talk to students about, teach students on particularly on the LLB curriculum, and what happens when we come across a case which isn't in the canon but we think is important. How do we go about thinking about the criteria for relevance? So, whilst the context is a specific case, which I'll say a bit more about in a second, and the LLB curriculum redesign, which you've been hearing quite a bit about from colleagues at the EOU already today, the points I'm going to make are of a more general application as well. And in fact, I start off with these points, which again, some of this will be very familiar. So why do we include some cases but not others? I'm just going to go through this very quickly because this is all stuff we teach our students in the first week after they arrive. Well, because they're in the law reports is one answer. And so I'm just hearing, I'm just muting a participant. Because they're in the law reports, and in fact, this quote from the Glanville Williams book was that was one of the first books I read as someone just about to start my LLB. And he says law reports are reports of the more general of the more important cases decided by the superior courts. Not all cases are reported, only those of legal interest. Whatever that means. It could mean a number of things, but one thing it does mean is that there'll be cases of some precedential value. These points could obviously be the other way around. We could have cases are included because they're precedents and they're in the law reports because they're precedents, but it doesn't really matter. And then there's this really interesting quote, particularly as people interested in legal history, from Cronman. He says, "The past is, for lawyers and judges, a repository not just of information, but of value, with the power to confer legitimacy on actions in the present." So it's an interesting distinction, I think, between a lawyer's view of history, which is very much looking to determine future behaviour. So what should we do now? Well, let's look at what does precedent bind us to do or guide us to do, versus historians, where there may be lots of reasons why we look at history, but thinking about what we're talking about today, often we don't look at history as a guide for what to do, but for what not to do. So these are things we know. Now, another reason why we might include some cases but not others is because they're in the textbooks, and we've already talked a bit about this today. And there's Dicey again, and a quote which sounds not as old as it is, but he says, "Particular authors of textbooks have notoriously, even in recent times, modelled, one might almost say brought into existence, whole departments of law." And I think that underlines actually the power, the role of textbook writers in shaping our subjects and in shaping what it is we tell students and what we don't tell students. So what happens when we have a case like, for me, the Mangrove Nine case, which doesn't fit any of these criteria? It's not reported because it was a first instance decision in the Central Criminal Court. There was not even a trial transcript. I've been to see the police files, Metropolitan Police files, in the National Archives. There's no trial transcript. There's some witness statements from police officers, and there's some interesting contemporaneous records, notes of police officers who were sent to observe the trial and make notes and report back, but there's no transcript as such. And obviously it's not a precedent because it's a first instance Crown Court decision, and it's not in the textbooks as far as I'm aware. So what do we do when we come across a case which we think is important, we think is relevant, but doesn't meet those criteria? Well, I'll come back to that question. But next, I want to say a bit about the case itself, just in case it's one which you might not be familiar with. You may have seen a film about it. So Steve McQueen made a film about it in 2020 as part of the Small Axe series. It's still available on the iPlayer, and it's well worth a watch. It's a really good piece of filmmaking. So it's named after the Mangrove restaurant, which was opened in 1968 in Notting Hill. It was very much a hub for sort of the Caribbean community in West London and others, some of whom were very much radicals, and it attracted the attention of the local police, who, I think it's fair to say, well, certainly impartially, I could say, raided the premises many, many times, ostensibly looking for drugs, but really it seemed to be a campaign of police harassment, and I'll come on to a comment at the end about that. But what arose out of it was this case, which actually is more accurately known as the Crown against Beese, Boyce, Critchlow, Gordon, Howe, Innes, Jones-LeConte, Kentish, and Miller. And these 9 individuals went on trial in October 1971 at the Old Bailey, accused of a range of charges, including riot, incitement to riot, and affray. And despite the evidence of around 40 police officers, the prosecution largely failed to convince the jury of their case. And the defendants were acquitted of 23 of the 32 charges, including the most serious ones of riot. So what I wanted to do with the case, and I wrote about it in this context, which is a module called Criminal Law in the Courts, which is one of the first modules the students will do on our new LLB. And I was writing unit 16 called Righting Wrongs, Miscarriages of Justice. Now, this case is not a miscarriage of justice in a kind of classic sense of someone being wrongly convicted, but very much miscarriage in the sense of a failing of justice. And the point being that these individuals did not receive the kind of standards which the criminal justice system claims for itself and which we teach our students, and particularly at the hands of the police. And the finding, as we'll see in a minute, of first finding of racism, institutional racism, if you like, against the Metropolitan Police. So that's the context. And I wanted to include some artifacts about the case, just to kind of bring it to life. So on the screen you can see a flyer showing 8 of the 9 defendants, which I think was distributed outside the Old Bailey during the trial. And that all helped to bring it to life. So students kind of work their way through the materials, and then there are a number of activities. And some of the activities I got the students involved with concern watching some of a video called Mangrove, and it was made by John LaRose, who was a contemporary and friend of the and kind of fellow radical, I think it's fair to say, of these individuals. And he made this film fairly shortly after the trial and interviews many of them who were involved. And what I felt was really important to do was to include the voices of the defendants themselves. And that was because I felt the case was best viewed through the lens of critical race theory, because that view of the world, that ontology, very much reflects the perspective of the Mangrove Nine themselves. So the Mangrove Nine, including leading writers like Darcus Howe, very much saw British society through a racial lens, very much understood Britain as people themselves from the former colonies, as a colonial project, as a post-colonial state. And so I think it really helped to bring it to life, really helped to understand the perspective of the individuals by hearing their voices, and I didn't want to mediate those voices in any sense. I wanted students to be able to hear them for themselves and to experience and learn from those experiences. Why is the case relevant there? If it's not, of precedential value, it's not reported, what are the arguments for its relevance in the law curriculum? Well, significantly, it was the first, unfortunately not the last, of course, official recognition of racism in the Metropolitan Police. And the trial judge, on summing up just before Christmas 1971, said there'd been racial hatred on both sides, something which very much got under the skin of the Metropolitan Police. And I'll come back to that in just one second. It's also significant, I think, because of the defendant's radical legal strategy and what it tells us about the agency, or their agency, and the agency of minorities generally. Jones-LeConte and Darcus Howe represented themselves in the trial. They did that for a number of reasons. One was particularly so they could express the experience of Black people, again, unmediated through counsel. So they wanted the wider social experience of Black people in Britain to be heard by the jury, and not to be, as they would see it, watered down or in any way diminished, minimised by counsel. It was also radical because they argued for an all-Black jury based on arguments from Magna Carta. That was unsuccessful as an argument, but they did successfully challenge jury selection and managed to shape the jury a bit about that in that sense. It's also significant for what the case tells us about the police's behaviour in the case, and we know from the National Archive file that the police did background checks in Special Branch and Criminal Record Office files for jury members and gave that information to prosecution barristers. And we also know that they tried to influence the DPP regarding this statement of racial hatred on both sides. So an assistant commissioner of the Met wrote to the DPP, this file is in the National Archive, asking for a meeting between the judge and the prosecution barrister, putting pressure on the judge to retract his statement of racial hatred in the Met. That didn't go anywhere, and the statement still stands. And there's an interesting comment from the barrister Ian MacDonald, who represented Barbara Beese in the trial. He says, it seems clearly to have been an attempt by the state to prevent the growth of organised resistance within the Black community, which had an independent leadership. And that seems to me to have been the real point of the case. It's also relevant for this reason, which we've been exploring quite a bit today. It's the same point that is made by Rackley and Ogmuti in a recent article, where they say feminist legal history seeks to resist and debunk the idea that legal history is inherently and inexorably progressive. So challenging this Whig notion of history. And in fact, what we see is that the criminal justice system is very much kind of falling short, and it providing a really powerful, I think, counter narrative to one of a progressive liberal state, and one where, in fact, in response to this case and other cases like it, the rules around jury selection changed, so they became more restrictive from a defendant's perspective, and also, of course, the case stands interestingly alongside, or powerfully alongside, the Stephen Lawrence murder and the Macpherson report and Macpherson's finding of institutional racism in the Met. Decades after the late, was it 99, I think, this case, where no doubt there had been improvements in that time, but still, institutional racism was found best part of 3 decades later, still to be present. And then just summing up with a couple of challenges and opportunities when dealing with these kind of cases. I think there's always a challenge about moving beyond a cause célèbre, isn't it? Those kind of cases that you read about in books you pick up at airports, which are all very interesting, but so kind of what's the point from a legal perspective? And the fact that, I think we've seen this today, we need to make the argument, because the inertia is against us, why these cases are relevant and why space should be made for them in the LLB curriculum. It's also a challenge if it's not in the textbook or in the law reports, just to get materials. And again, we've talked about, a lot of us I'm not a trained historian, so going to the National Archives, which I went to anyway because I was thinking of writing a paper on this, not just for the curriculum research. It's fascinating, but it takes a lot of time, and I'm not necessarily equipped as a historian would be to analyse these materials. Though I do my best, and I'm learning a lot as I go. And then just finally, a quote really from my colleague Caroline in a really recent piece. which I think really summarises my argument well, I think. If we treat this case, she was talking about another case, but I think it applies to the mangrove, as a piece of legal history alone, it's of limited interest. It did not establish lasting precedents. Conversely, if we only look at it as social history, we miss many of the nuances and learn less than we might from it. The case is a good illustration of the value that socio-legal reading of historical cases can bring. And I think that's why the mangrove does have an important place in the history of anti-racism in the UK. It challenges perceptions of an impartial criminal justice system, and it emphasises the defendants, or shows the defendants, not as passive recipients of justice, but as successful agents in their fight against unfair treatment. And I'll finish there.